NACDL is the association of the nation's criminal defense bar.
Hello, this is the first of our 3 parts on appellate practice, and we're going to start off by talking about some of the mechanics, the basics of appellate procedure, with some focus on the early part of the process. And then later in this hour, we're going to get into a deeper focus on issue selection. I'm going to be doing most of the talking with some interplay and questions from Steve and Catherine for this hour, and we'll be switching roles in the later segments of the program. So an appellate case obviously is a new stage of the case, and it may be that you were the trial lawyer, or it may be that you're new in the case. Most of what you'll be doing is the same in either situation, but let's talk about first about the situation where you are new in the case. So that would be either you've been hired in a private setting, or you've been court appointed if you're a private lawyer on a panel for appointment, or perhaps you have inherited the case within your public defender office because you're in the appellate division, or someone else has left the office and it's become your case for whatever reason. In any case, it's a good time to stop and ask yourself, is there a conflict of interest here? This is a new time to ask yourself conflict of interest. Even if you were the trial lawyer before, there can be conflicts on appeal. We may talk about that a little more in the third hour when we talk about ethics, but because we're talking about what to do at the beginning of an appellate process, I think it's important to mention that a conflict of interest can arise on appeal. And sometimes we're tempted to say, and I know I have personally been tempted to say, we can be less concerned about conflicts on appeal than at trial. And I will never forget the time I agreed to represent a husband and wife in a tax case, a joint tax return, same legal issues. I was totally convinced this was going to be fine. And of course, the divorce developed while the appeal was pending, and each of them tried to use me against the other for personal reasons. And I was very sorry that I accepted these 2 clients at the same time, who I would never have accepted in a trial setting. You couldn't have, right? Or in at the sentencing setting, when necessarily you're going to be pointing fingers. This one's more culpable than that one, or less culpable than that one. So my suggestion on this point is err on the side of there's a conflict. Of course, if you're in a public defender office, your office is going to have a policy on conflicts. Some policies are pretty strict, and some would seem to an outsider pretty lax. Sometimes that depends on resources, and you need to work that out with your own office and supervisors and check office policies. Did you want to add anything on the public defender aspect of conflict checking?
A lot of times the conflict check would have occurred at the trial stage too, so it really is a continuation of representation within the public defender system a lot of times.
Right. Although your office may inherit a case that a private lawyer had, and then the client ran out of money, and you're in that particular jurisdiction, the private lawyer isn't getting appointed for whatever reason, then
right.
You could acquire a new case with that problem.
Based on ethics.
Right, of course. So at some point you are, even if fleetingly in your mind, accepting or rejecting the case, having worked out an appropriate retainer agreement if it's private, or satisfied yourself that there's no conflict. So the first thing we think about, of course, when we take an appellate case is, what's the client's liberty status? Is this client detained or not detained? If the client's already been detained pending trial and sentencing, maybe this is not an issue. Less likely that this client's going to be freed on bail pending appeal, having been detained at the time of sentencing, but it's not inconceivable, worth having that thought cross your mind. But if the client's at liberty at sentencing or following sentencing, then this is a serious question. And I'm going to use this to say for the first time, and certainly not for the last time in this hour or in the next 2 hours, that it depends on the rules of your jurisdiction. So every jurisdiction, every federal circuit, every state, maybe even differences within states, who knows, are going to have a statute or a rule or both that govern bail after sentencing and potentially bail pending appeal. I learned a new phrase preparing for this program called freedom bond. It's a lovely sounding word that's used in Virginia, maybe in some other places, that I know in my experience as bail pending appeal. I like that, freedom bond. It sounds like something you buy to help win World War I or something. But in any event, there are going to be rules. There are going to be, well, let me put it this way, there are going to be criteria. Is the person potentially eligible? There are going to be standards. If the person is potentially eligible, does this person meet the standards for getting bail? And there are going to be procedures for seeking it, and all three levels may vary within the jurisdiction. I'm going to break this down also and say that there are two kinds of bail after sentencing to think about. Even if the client is not eligible for bail pending appeal because they don't meet the standards, they don't have the criteria, the client may be eligible for bail pending commencement of sentence, what we call in federal court pending voluntary surrender. This is particularly significant where the client is, in your experience or in what you've been advised, eligible for minimum or low security incarceration, if they're facing incarceration, of course. But if they go into custody shortly after sentencing or immediately after sentencing, they're going to be in the county jail awaiting transfer to the state system. And the county jail is almost certainly maximum security. So bail pending surrender, even for a client that isn't going to have bail pending appeal, is something that you want to think about, particularly for clients that are going to be eligible for minimum or low security. And this is an area where, in my experience, where I do mostly appeals and rarely am in the trial court, I'm going to be working very closely with the trial lawyer or the lawyer that did the sentencing, if that's a different lawyer, to be clear who's handling this, who's going to do what part of it, who's going to do the writing, who's going to do the talking if there's any talking to do, because you may be working as a team at this stage. You're in transition between the trial court and the appellate court.
I would just add to that, if the trial court denies bail pending appeal, that most jurisdictions have a separate appellate process for appealing the denial of bail too.
Oh, good. Thank you for mentioning that. Yes. Right. And that may be in itself a kind of summary appeal, or it may be a simple motion in the Court of Appeals, again, depending on the jurisdiction, and in some jurisdictions, depending on whether the notice of appeal has yet been filed. Right? In the federal court, for example, in federal court, it's you have to file an appeal to seek anything from the Court of Appeals unless a notice of appeal has already been filed. Once the notice of appeal has been filed, the federal court, the appeals court, has created a docket for the case, and your bail motion is a motion in that docket. And I would be guessing that in any given state, it could be any of those.
In Virginia, it's done by motion to the Court of Appeals. However, if you want to appeal from the Court of Appeals to the Supreme Court a denial of bail pending release, you actually have to file a separate notice of appeal and a petition for appeal. So it actually depends on courts too, and again goes back to the court rules.
Yes, and it occurred to me that it may be a writ in a given case. There are circumstances in Pennsylvania, for example, where you seek habeas corpus in the appellate court to get bail because for whatever goofy jurisdictional reason they say they don't have jurisdiction otherwise over the bail matter. So again, this is a local peculiarity, one of 1,000 that we'll probably be mentioning as we go along. So I've already mentioned the notice of appeal. Here's an interaction. These are the two things that are happening right after sentencing in the first few days, right? When is the notice of appeal due? Absolutely a matter of local law. It may be a statute, it may be a rule. That rule may be in your rules of appellate procedure, in the rules of criminal procedure. And if you don't know, you should ask someone and look it up, both. If you do know, you should look it up anyway, because the rule may have changed, you might be mixed up, you might be forgetting, whatever it is, and this is not one you want to make a mistake on. So here I am, nearly 40 years into practicing appellate law, hundreds of appeals that I've done. I open the rule book every time to remind myself, oh yes, that's right, it's 14 days. It used to be 10, but now it's 14. And the 14 are counted how? Oh, starting when? And do weekends count, or do they not count for this? Can vary from jurisdiction to jurisdiction. Any 3 lawyers from different parts of the country will tell you count to 10 in 2 different ways.
And Peter, I wonder if you're comfortable regarding the notice of appeal, whether you're the trial attorney or the new appellate attorney, assuming that the deadline is basically now.
Right. So as an ethical matter, the responsibility to file the notice of appeal, or to see that a notice of appeal is filed unless the client has waived the right to appeal, or whatever the standard, however the standard is expressed in the case law of your jurisdiction, is on the lawyer that handled the sentencing in most places. That's the ethical responsibility. It's not that lawyer necessarily who will file the notice of appeal, but I would say it's that lawyer's responsibility to first think about the question of, does this client want an appeal filed, and see that it is filed. If there's a new lawyer handling the appeal, as is typically in my situation, and I probably will have come into the case in the sense of having been hired before the day of sentencing, even though I'm not maybe doing the sentencing, we will have talked about who will take care of filing the notice of appeal. And being an appellate snob, I will say, I want the appellate lawyer to draft and file the notice of appeal, because there are little things you could do wrong in drafting it that's kind of in my special wheelhouse. But who's going to do it should be talked about out loud between those 2 lawyers as part of the transition.
And I also think when the notice of appeal filed, besides obviously meeting the court's deadline, but sometimes the filing of the notice of appeal can divest the trial court of jurisdiction then over certain matters. So if you plan on filing post-trial motions, you might want to stay until you have the final judgment order, or do the post-trial motions before the deadline for the notice of appeal, so that you can file the notice of appeal after, to make sure that it's encompassing all those adverse rulings against your client.
So already that's going to depend on the jurisdiction.
Yes.
You're talking about a jurisdiction where motions are filed after the pronouncement of sentence, I imagine. And maybe I should have said out loud what's been implicit in what we've been saying so far is that in a criminal case, the notice of appeal, an appeal, let me just say, the appeal in a criminal case is a single appeal that encompasses the conviction phase and the sentence, and is typically filed after the sentencing, not after the verdict is returned or after the guilty plea and before the sentencing, even though the client may say, I want to challenge my conviction, I don't want to go to sentencing, I'm ready to appeal now. Okay, but this is not the time we do that. Similarly, the time to file post-trial motions, let's say in federal court, which I'm more familiar with, is after the verdict and long before sentencing. There are no motions to be filed after sentencing unless there is a technical error in the sentencing to be corrected in the very short period after sentence is imposed. Or you have some special arrangement about rewarding cooperation that's going to happen, and that can also happen right after sentencing. But otherwise, the circumstance that you just brought up, which I assume reflects your experience in the state of Virginia in particular, no such thing would exist in federal court. But there will be a rule about what if motions were filed, be it before or after sentencing, and the judge hasn't ruled on them yet. Does imposing sentence cause those motions to be deemed denied as a matter of law? Or are those motions still pending? And if so, do they delay the time for filing a notice of appeal? Or do you need to file your notice of appeal anyway? That can happen. And in Pennsylvania, just as an example that I know, it depends on what kind of motion you're talking about. I just was in a case in Pennsylvania where the judge had 30 days after we have a 30 days to file the notice of appeal in our state, and the judge had 30 days to rule on a certain kind of motion, which if not ruled on within 30 days would be deemed denied. But if we filed the notice of appeal, that would terminate her jurisdiction over the motion, and we wouldn't be able to get that motion ruled on. So we knew in that unusual situation, we had to file the notice of appeal on day 30. So we could maximize our client's opportunities in both respects. So the impulse to file the notice of appeal immediately, which often the client has, is not always tactically wise. It depends on the circumstances of a given case. Yes. And then what does the notice have to say? That may depend on your jurisdiction as well. Do you have to name the rulings that you seek to challenge on appeal in that notice? Not likely, but maybe in your jurisdiction you do. More likely, you only have to name the judgment which finalized the case at the district court, right? Which is to say the written sentence. But again, depends on the jurisdiction. Do you have to name the court to which the appeal is being taken in the notice? Some rules say you do. Do you have to state the date on which that judgment was rendered or pronounced or entered, or some other technical term about a date which may be 1, 2, or 3 days different from one another, who knows, depending on what the clerk did. These are all things which are clearly stated in a rule, and if you just follow the rule, and if you're uncomfortable, check with a colleague who's done a lot of appeals and make sure your reading of the rule has been correct, right? And I think in the great majority of jurisdictions, that notice of appeal is likely to be filed with the clerk of the trial court. Because what is a notice of appeal after all? A notice of appeal is really a directive to the clerk of the trial court to gather the record and transmit it to the appellate court you've named in the notice, inviting that clerk to create a new docket. That's really what a notice of appeal is, right? Not that it says those things exactly, but that's mechanically what it is. And probably there's a filing fee that goes with that, unless you have forma pauperis status. Your forma pauperis status may be automatic in connection with that notice of appeal, based on having had court-appointed counsel at the last previous stage, or it may have to be sought again. You may have to file a motion for leave to proceed on appeal in forma pauperis again. This could depend on your jurisdiction, right?
I think the reliance on the rules can't be overstated. I think a lot of law students and a lot of new attorneys think there are these rules and they're somehow maybe admonitory or it's just a rough guideline, but these are the rules, the federal or the state rules of criminal procedure and appellate practice. Most of the answers are there. Sure. And courts follow these rules, so you just need to know those rules, and where you don't, or where you need to be reminded, look to the rules.
Should I keep giving examples of things I've done wrong in violation of the advice I'm now giving, or where I learned this advice? I had a case years ago, right, where I filed a notice of appeal from the denial of reconsideration of the order that we were appealing. I don't think it was a sentencing in that case, but whatever it was. The underlying order was appealable, but it could be reconsidered in the trial court. We had asked for reconsideration. That had been denied. I referred to the date and the order denying reconsideration, and I neglected to mention the underlying prior order. The Court of Appeals ruled that I had preserved an appeal only from the highly discretionary and not going to win this on appeal order denying reconsideration, and not from the underlying order. Learn that lesson. You can make, it's just, I don't mean to terrorize anyone, but there are so many, just stop and think. And the lesson, what is the lesson from that story? Lesson is, be cautious, be conservative. You're not going to get in trouble by saying a little too much in the notice of appeal about what you're appealing if there's some doubt. Don't be silly about it, but if there's some doubt about what you need to mention in the notice of appeal, there's going to be no harm, I would think, in being conservative in your assumptions.
And also know, everyone's human, mistakes are going to be made, but the earlier you catch your mistake, you might be able to fix it by either filing a motion for an amendment filing an amended notice of appeal, or to see if you could file a motion for an extension of time so that you can file a new notice of appeal. So the goal is perfection, but short of it, the earlier you catch the mistake there, the more that you may be able to do to fix the problem.
Oh, thank you so much for saying that. And perhaps even it might be called a supplemental notice of appeal that doesn't start a second appeal, but just clarifies or even expands the scope of the appeal that you've already initiated with that first notice that maybe had a defect of some kind. Likewise, let's talk for a minute about what if the time has gone by, right? What if somebody has made a mistake or neglected their duties and then you get brought into the case later? Again, the rules in your jurisdiction are going to provide the answer to this. There may be, likely is, some provision in the rule on notices of appeal about extensions of time to file a notice of appeal, or and something about the criteria for that, and maybe a time limit for doing that. If it's a jurisdiction that says any time limit under these rules can be extended other than the time for filing a notice of appeal, which is not unheard of, then you need to wave your magic lawyer wand and know the Latin expression nunc pro tunc, because you find something that's filed nunc pro tunc, now for then, is something which is not late. It's deemed to be on time, even though it happened later. So your jurisdiction may allow that. May not, but it may, right? And if an amendment is not possible, if the time has been screwed up in some way, if nunc pro tunc is not available, then there is probably a provision either in the general post-conviction procedures of your jurisdiction for filing a summary, easy, quick, oops, I admit I made a mistake and didn't file the notice of appeal on time, vacate the judgment and re-enter it so the time can start running again, or something like that. That happens, believe me, this happens a lot, and can be routinely granted. And I think when we were chatting yesterday, Catherine, you mentioned that there might even be a simpler procedure in some jurisdictions.
Right. In Virginia, there's kind of a shortcut to doing a habeas where you can file a motion for a delayed appeal. So if you fail to initiate that appeal, or if the appeal is dismissed for failure to follow proper procedures or time limits, you can simply file a motion. The attorney files an affidavit admitting the fault, and the client can have a delayed appeal with a quick turnaround.
So having admitted fault there, is the lawyer deemed ineffective, or is it just like something short of ineffectiveness?
I think it's meant to prevent a finding of ineffectiveness,
right,
to kind of just shortcut the process to benefit both the client and the attorney.
So it doesn't conflict that lawyer out the way a finding of ineffectiveness
right,
probably would.
Right, it does not conflict an attorney out necessarily.
Well, that's a very, very civilized procedure.
Yes.
Well, in federal court, there are provisions in the federal rules of appellate practice for filing any motion, and you could file a motion admitting that you missed the deadline, and could the court please extend it? The implicit argument there is, well, if you don't, then we have to go through 2255 and go through the district court
right,
and waste a lot of time,
right,
and we're going to get to an ineffective assistance finding anyway, and you're going to hear the
correct
case.
So I would give that as an example. See, my rules fanatic self wants to say, I agree with what you just said, Steve, subject to the explicit time limits in Appellate Rule 4, Federal Appellate Rule 4, that say when you can do something like that. And then I hear the birdie in the back of my mind saying, unless nobody objects, because there's rule 0 in every set of rules, probably in your jurisdiction. Whatever everybody agrees is the right thing to do and the judge is willing to sign might as well be the law in most places. I can't promise that, and I can't promise the Court of Appeals is going to accept it later and not find a jurisdictional defect. But in desperation, it might even be possible to do something that doesn't comply with the rule in that kind of respect. So, having filed the notice of appeal, this is going to trigger, in most jurisdictions, I would say in all jurisdictions, under the practice of a given appellate court, an obligation to file some case opening paperwork, We're not going to go into the details of any of that because it's going to vary so much from jurisdiction to jurisdiction. But what we're talking about is something which is or is maybe even called a docketing statement, maybe a simple form that you file for the benefit of the clerk of the Court of Appeals. Once that case has been docketed in the Court of Appeals and given its own number, that just briefly says, in my experience, and maybe you can tell me if I'm wrong, that this occurs in most places. What kind of case is this? It's a criminal case. Is it an appeal from the trial or from a sentencing? Who's the lawyer of who's going to be lawyer of record? And maybe not too much more than that. And what's your claim? Maybe I've seen in some of the federal circuits, the docketing statement varies from circuit to circuit. The Seventh Circuit wants you to explain how you calculate that there's appellate jurisdiction, for example. Last time I filled one out in that court. It's like, what was the date when this order, when the appealable order was entered? What's the date when you filed your notice of appeal? Was it a final, check yes or no, was it a final order? If it wasn't a final order, what gives you a right to appeal? That might be in the docketing statement too. You're not going to file a brief with that, but just an assertion of the general nature of the case.
And by contrast, in Virginia, we have no such thing as a docketing statement. So after the notice of appeal, it's really about getting the transcripts filed,
right,
objecting to the transcripts, and making sure that
right,
that record before it transfers is
right,
complete.
So the other typical case opening documents that you might find in a given jurisdiction would be an entry of appearance in the Court of Appeals. But again, having signed the notice of appeal may be deemed an entry of appearance in a given court. Or your court may require a separate one, and something about ordering transcripts. That's almost certainly going to be, and the one you're going to be delving into.
Yeah, in the Eighth Circuit, we don't have a docketing statement. It's a relatively simple process. We just file the notice of appeal, file an entry of appearance. There is the transcript issue. We have to order it or certify that we
Right,
won't order it.
right.
And
how are you going to pay for it?
if you're privately retained, yes.
Well, regardless, it's,
Sure.
there's going to be something on that transcript order form saying I'm court appointed,
Right.
or I'm with the public defender, or I'm going to pay for the transcript, and I have worked this out with the court reporter. Because your court reporter might, if you're privately retained, your court reporter may require a down payment, or she may not. But either way, there will be a process. You can learn from another, someone with some experience there, or even from a clerk in the Court of Appeals about how to reach out to the court reporter if you're privately retained, and make sure you've got your arrangements lined up for getting transcripts that you need.
Clerks are very helpful. What I've found working with federal district courts in trying to get the transcript, or perhaps docket entries that are sealed or otherwise unavailable, is sometimes when you file an entry of appearance in the federal appellate court, that doesn't quickly translate to being the attorney of record in the district court. So you might have to communicate with the district court clerks to get your name on the docket so that you can get access to the docket entries that are sealed, and so that you can enter e-voucher if you're in federal court.
Dear, yes.
Order the transcripts and pay.
I've had that experience, yes, several times, and in particularly where the client was cooperating, or for some other reason one of the transcripts is under seal, and I need a sealed transcript to be produced, and the court reporter says, I can't make that transcript for you, it's under seal. And I say, but it's my appeal. I'm counsel of record in the Court of Appeals. And the court reporter says, not in my court, you're not. And now here I am filing a motion in the district court, maybe even entering an appearance in the district court with the trial judge that seeks access to sealed transcripts on the same terms and to the same extent as trial counsel had access. That's typically what my motion like that will say.
Interesting. I've never had to file a motion. I just call the clerk, but different courts are going to differ.
It's not even different courts, it's different judges. I've had in the very same court a judge say fine to the court reporter, and another judge say file a motion. And so what are some of the other problems with getting transcripts is we're going to, my next thought was going to be get a complete copy, if such a thing exists in federal court, thank goodness they do, of a docket, that is to say, the chronological index of everything that was ever filed in the case. That's called a docket in federal court, and maybe in a lot of other places as well.
We call it a table of contents of the record.
Yeah, sure. And go through that meticulously and put a little check mark next to each one, and we call that the shopping list in our office. And that's going to, what documents am I going to need a way to find to get in my hands? And in particular, when were there in-court proceedings that have not yet been transcribed, of which we may need a transcript? So this is preliminary to making that transcript order, right? Because many times I've discovered an item on the docket that says pretrial conference, doesn't say what it was about, and it turns out we order it because we don't know that we don't need it, and sure enough, there is some oral ruling that makes a difference later in the appeal that the judge or the lawyer brought something up that means the issue was preserved, and otherwise maybe it wasn't, at something which the docket mysteriously just refers to as a pretrial conference. Sadly, there are some courts, and even within the federal system, where a given clerk doesn't make as good a docket as some other clerk, and there are times when you later learn, because it's mentioned in passing in the trial transcript that you're reading, that there was a pretrial conference on this or that at which something or other was decided, and you never heard of that conference, and it isn't mentioned on the docket. And you may have to suspend the proceedings in some way and go back and order another transcript later. But you're going to do your best at the beginning to identify all the transcripts you're going to need and order them. And again, err on the side of caution if you possibly can get all the transcripts, right? Some jurisdictions also, I'll just mention, have a procedure where early on you're supposed to identify to the lawyer for the appellee, the prosecutor's office, what you propose to argue in your appeal and include in the appendix or reproduced record or excerpts of record or whatever that's called in your jurisdiction. And why so early? So that they could also place a transcript order in case you haven't ordered something that they think is needed. There's a provision in the Federal Rules of Appellate Procedure like that. It's honored, to be honest with you, more in the breach than in the observance, because it's so impractical. Because if you're new in the case, how are you going to be able to answer that question at this stage of the proceedings? It doesn't really make any sense, but I just mentioned there's a provision in Federal Appellate Rule 10 that says you're supposed to do that. And although I'm a fanatic about following the rules myself, I will admit I almost never follow that rule because you can't.
Some states, like Virginia, they put the burden on creating the record, including ordering the proper transcript, on the appellant. So
I think almost everywhere that's
if the
at least
appellant
principally the
raises
case.
an issue that can't later be determined because there's something missing from the record, that's going to be the appellant's fault, and the appellate courts will then not consider the issue or consider the issue waived because you didn't meet your burden of having a complete record, which is why I do err on the side of ordering more or all the transcripts than less, because I do realize we have that burden.
There are jurisdictions like New York and New Jersey are like this, where a lot of communication between counsel and the court is done by what they call letters. I mean, they are letters. They're written on letterhead and they're single-spaced, and they may or may not even have been filed, and yet on appeal they're treated as part of the record by common consent. So this is a practice question in a given jurisdiction that you might need to know about if you don't know it yourself from someone with some experience. There are little oddities like that. Some places, in the way you're describing, Catherine, can be quite strict about what's in the record and not in the record, and other places, I'm thinking of New Jersey and New York that way, it somewhat lax in that respect, but don't count on having the benefit of any laxity, right? And the other thing you might want to learn early on, I think all of us will admit, is what are the rules and what is the culture of extensions of time in a given jurisdiction. And you want to, for what can a time be extended and for what can it not? Will it be readily extended, or do you need a pretty good reason? Can things be extended once but not twice? And here's this one you cannot tell in my experience, you cannot tell from reading the rules. There are plenty of places where it says the court strictly disapproves of extensions of time and extensions will rarely be granted, and the opposite is the truth. And there are places where it is the truth. And for that one, I would say, an appellate chief in your local public defender's office, an appellate supervisor, is the most likely person to really know the culture of the court with respect to extensions of time.
And I would think an extension of time filed before the original deadline is due is much more frequently granted than being in a position where you end up filing the motion for the extension after the deadline, but still within a proper extension period. That's when courts tend to be less forgiving. So even though it might be a timely motion for an extension, when you first realize that you need the extension, that's the time to file it.
Right. Or that after the deadline has run out, motion might be a motion for leave to file out of time, because now you're 3 days late, but it's done. So that might be it's a related sort of motion. And again, is your court going to grant that motion? Are they going to grant it with a sanction, or are they just going to grant it with a tut-tut, or are they going to grant it with no comment at all? Again, that's a culture question. So briefly on the attorney-client relationship in appeal, let's talk about introducing yourself to the client, be it in person or in writing or on the phone, any or all of those things. I come into cases on appeal. Sometimes the client is incarcerated. We have never met face-to-face. Sometimes, because I do mostly federal appeals, that client is hundreds and hundreds of miles away. There are clients whom I have represented for years and never met face-to-face. I think we would all agree the ideal is to try to meet the client face-to-face at least once. This may not be feasible in a given jurisdiction because of distance and time. It may not be feasible because of public defender resource issues. But if it can be done, it ought to be done. I think that's safe to say. But if it can't be done, certainly you want to introduce yourself to the client in some way. Having talked to the client's mother is not enough. Having been referred by the client's trial lawyer is not enough, because even though this relationship is not as intimate as a trial lawyer relationship with the client, perhaps, I think it's fair to say, certainly not as intimate as the lawyer-client relationship for negotiating of a guilty plea or a sentencing, which is so stressful and emotional. This is a bit colder, and yet still you have a client and you have a relationship, and you need to create it and cultivate it, right? So the written part of that is, and this may be an ethics rule in your jurisdiction. If it's not, it's certainly good practice anyway, to write a letter to the client at the beginning saying, what is an appeal? What is the scope of an appeal? What is the scope of your representation? What does it mean to be the new lawyer? You have taken over responsibility for the case as of when and until when, right? And what is covered and what is not covered in this relationship? To what extent are you available to answer other questions, if you want to touch on that? Will you, can you facilitate communication in any other way, or providing them documents in some way if they want to look at their own documents? And in my case, in private practice, I also make a rule that I will communicate about their case with their permission, and only with their permission, with one friend or family member. And that person will be responsible for communicating with the rest of the family and the other friends, because I can't take phone calls and be explaining the case to 3 or 4 family members of a given client. I also try to ask the client in writing, and then if in a phone call, if not in person, tell me what you think went wrong. What is it that's bothering you about how this came out? And I try very hard not to phrase it as, what do you think the issues are on appeal, right? Tell me what's bothering you about how this came out. Sometimes clients want to tell you about issues anyway, and we'll be spending some time later talking about that. And I say a phone call because if you can't get there in person, find out how you can get a private attorney-client call with a client incarcerated in the place where your client is if you can't get to visit him or her in person. Almost every prison has such arrangements possible. If they claim they don't, I would not take no for an answer about that without some escalation of that request to a higher level of authority in the prison or the lawyers for the prison system, if it even came to that. But try to have a private, unmonitored phone call with the client where they can tell you what went wrong and in their own minds and how they feel about their previous lawyer. I mean, many clients come to us as appellate lawyers with a very, having just had a horrible experience, a bad outcome, and bitter feelings, justified or unjustified, toward their previous lawyers. So this is a chance to have a clean slate with the client, show you're on their side.
As far as getting that attorney call, I send a letter as soon as I've been appointed or I get a new client. I say, I don't know anything about your case. I'm just starting out, but I'll set up an attorney call. I call the prison, and whether it's high security or low, prisons vary in terms of how well they'll help you. Some make it very easy. Others will give you the runaround.
Right, and this is not even jurisdiction by jurisdiction.
No,
this is prison by prison. It's the warden's
and
culture.
It's counselor by counselor sometimes.
Yeah.
And oftentimes, I have a sense that prisons are very understaffed, and counselors are stressed, and so they often delay and delay and delay. I've had to call the BOP in Washington claiming that I was being denied access to my client. That actually gets traction, and all of a sudden you get an attorney call. And your clients,
I've never called Washington, but I certainly have called in the federal system. I've called the regional lawyer.
Call the regional
in the
counselor.
region, and that usually works.
And clients.
My
see
favorite is
that.
the regional lawyer will say, "I cannot help you with this, but I'll see if I can find out what the problem is."
Right.
And then 40 minutes later, the counselor calls and apologizes and gets your client on the phone.
Yes, and and clients see you do that work. They recognize it, and I think you can get a lot of trust built up by getting to your client as soon as you can.
Right. So now let's say we've established that relationship. We've had that private call. What are you're going to need to go back to work, and the sooner, there are some things you just need to do right away, and one of those is compile this file. Get the trial lawyer's file if you were not the trial lawyer, but don't accept the trial lawyer's file as being what you're going to need. It's going to be a trial lawyer's file. It's going to be organized for a trial or not organized. It's going to be incomplete. If the case went to trial as opposed to a guilty plea, I've never seen a file that wasn't a wreck after trial, right? It's just because stuff that's the way trials are. And some lawyers are great in helping, and some lawyers are a pain, and it's hard to get the file from them at all. Sometimes I've had to threaten people to get their file, but for other private lawyers, they're on to the next case. This is something they're not getting paid to do. You're asking them to do something, that requires some time to get papers from wherever into a box and ship it to you, even at your expense, or so that you can go pick it up, or hire someone to pick it up if it comes to that, or something like that.
And the attorney might ask, what portion of the file do you want?
Oh, yes.
The answer is all of it.
Everything.
I should
Right,
think.
because you don't know at this point.
Right.
You don't know, and is that an error I have made over and over again, is thinking, I don't need that. I don't need that. I don't need the discovery. I'm always trying to convince myself I don't need the discovery. And usually, you know what? You don't need the discovery to do the appeal, but one time you will. And so have it is better.
I have a question. When I'm dealing with the federal public defender in the past, oftentimes they've said, sure, we're happy to send you the file, except of course for our work product. My philosophy is we're on the same team. You should show me your work product. But I respect that because it's work product, and I probably don't think there's anything I can really use.
I think that's probably wrong under the ethics rules of most jurisdictions. I think the file belongs to the client, and the client, in a retained situation, has paid for that work product to be created and owns it. I think, and I would think the public defender situation would be equivalent, but maybe I'm wrong about that.
Certainly we're all in Virginia, it's still all within the same office, but the entire trial will go to whoever is handling the appeal. And I agree, I view it as the client's file. And so the client, I believe, would be entitled to that work product.
Right.
So indirectly, the client should be able to request it and then give it to you. I haven't encountered any of those problems.
If the case went to trial, the hardest thing to get a good set of, in my experience, has been the exhibits. If it's a federal case and it was well presented by the government at trial, all the exhibits may be in a binder that you can get the defense lawyer's copy of, but the defense lawyer may have left that copy in the courtroom after the trial. You just don't know. There may or may not be a PDF compilation. If your appellate court uses electronic filing, as most of them do now, you're going to need everything in a PDF form, and please not scanned, but the original PDFs, so that you don't have 100 megabyte, file of something that could be a couple hundred kilobytes.
Sometimes you might need to visit the trial court or wherever the complete record is held with the exhibits to go and actually go through the boxes of the exhibits too, where if you can't have a copy, at least you get to see it and take notes and keep it all in context.
Or make a copy, hopefully. Yeah. If the lawyer just isn't going to gift you a whole file, there are other ways of getting the file. The clerk, things that were filed of record, you can get a copy from the clerk by downloading it, or if it comes to that, going to the courthouse and making a copy, or calling up and begging them to send you a copy, whatever the case may be in the given situation. And again, the problem of sealed documents comes into play here as well. Jump through whatever hoop may or may not exist for getting any part of the record that was under seal. Occasionally you will order transcripts and they come, and I'm going to urge you to look at those transcripts right away, even if you're not going to be able to read them right away, and ascertain as best you can, one, are these transcripts incompetent or are they professionally prepared? That is, there are some court reporters, as there are plenty of lawyers, who are just not good at their jobs. And you should be able to tell by reading a couple of pages whether there's an excessive number of inaudibles and mumbo-jumbo nonsensical transcriptions. In other words, are you going to have to fight with this court reporter about corrections to this transcript, or is this going to be pretty good? Or has there been a misunderstanding or miscommunication and the court reporter left out the sidebars? Had that more than once. Or, God forbid, something which I have seen, I think, 3 or 4 times in my career, you get told there is no transcript, or a transcript is unavailable of this or that. Had an appeal to the First Circuit from a trial in Puerto Rico. The court reporter's notes she was keeping them in her garage before they were typed up. I ordered the transcript. There was a hurricane. The notes were destroyed in a flood in the garage. Now there's no transcript of the prosecutor's closing argument, and the trial lawyer is telling me there was misconduct in the closing argument. We had an evidentiary hearing under a rule of appellate procedure that exists in federal court. I imagine there's something equivalent in every jurisdiction. If a transcript is not available for whatever reason or is inadequate, you can recreate the record in some way. It was a pain in the neck, but we did it. I went to Puerto Rico. We had an evidentiary hearing on the question of what did the prosecutor say in his closing argument. And the judge made findings.
This does happen, unfortunately, not a lot, but probably too frequently. Another thing that I suggest to attorneys is to use that as leverage to file a motion for a new trial. And that's what's important, to review the transcripts as soon as possible, or to know, because you can go back, hopefully if you still have jurisdiction, or you can somehow file some kind of motion for a new trial, because if the record can't be recreated, we do something called a written statement of facts in Virginia, but if the judge can't certify that that's actually what happened, so if the parties don't remember, and if the judge can't certify, there's case law that supports a right to a new trial.
Right. So, I mean, and what that's built on is the client has some kind of right to an appeal. It's less of a right in some places than others. There's no universal federal constitutional right to a direct appeal. It's a statutory right, and the extent of it may vary from jurisdiction to jurisdiction. But once that right is triggered to whatever the extent there is, then there is a due process right to a meaningful appeal of whatever that appeal is. And the Supreme Court did hold in the late 1950s, I believe, or early 60s, that a transcript is a necessary prerequisite to an adequate appeal where you have a right to appeal. And that's what lays behind the comment that Catherine was just making. So, and this can be great leverage when they're saying it's too much trouble to recreate or even to find. They will sometimes I've had that happen, the missing notes. Okay, fine with me. I'm filing a motion for new trial because I don't have an adequate record for appeal. Then they will somehow find the missing transcript, or the judge will get on board with a procedure for recreating what happened. And another time when that happened, court reporter went home sick, emergency in the middle of the day. They had to call in a retired court reporter to cover for her in the afternoon, and then that court reporter died before the record was compiled, and nobody knew where he had the notes from that afternoon. And the prosecutor was lazy, and the judge was uninterested in holding a hearing, and I got to do the investigation. I interviewed everyone that was there about what questions were asked and what answers were given, and I wrote a narrative of what I, who was not there, believe happened and what was said by the two witnesses who testified that afternoon. And because I put the work in, the judge accepted my narrative. And that became the record of what happened that afternoon. Any crazy thing can happen. So now we have the record. What are we going to do with it? When you have that block of time ready, you're going to review that record completely, right? And obviously, read the whole transcript. If you weren't the trial lawyer, and you know what? If you were the trial lawyer, you may be able to read it a little more quickly, but you'll be surprised to see what happened at the trial, even though you were there, that you don't remember happening that way. Or, oh, I did preserve that. I thought I didn't. Oh my God, I didn't preserve that, and I thought I did. Or whatever, the prosecutor said something that you didn't hear that the court reporter did that's important. Or the witness phrased something differently from the way you thought it was going to come out and thought you heard it at trial. And it's different in the transcript in a way that makes a difference to your appeal.
And reading your own transcript can be a very painful process.
Oh dear.
So let me acknowledge that, but it can be a great learning experience to improve your trial skills as well. So it can be a good learning tool in that regard.
And of course, when we're reading also all the pretrial motions and the post-trial motions, mid-trial, whatever, what are the things that are going to be fertile grounds, though, for looking for issues besides reading the transcript? Well, surely the motions that were actually ruled upon, those rulings. But I would say, we're also going to want, in particular, to reread the charging instrument. Does your jurisdiction use indictments where technical, correct pleading is important? Or is your jurisdiction one that uses indictments or informations and it's not an important issue on appeal exactly what's said in that instrument? But federal court, the writing of the indictment, the drafting of the indictment, the manner of it can be quite important, and you may have issues in that regard which are fertile that you didn't even think about. The trial lawyer maybe didn't even think about. Maybe an element is missing from the indictment. It's a non-waivable defect in the indictment, perhaps, in the law of your jurisdiction. And the other thing is, there's a doctrine of constructive amendment. When you look back at the end of the trial, after the trial, and look exactly at what the client was charged with and on what theory and based on what basic set of facts, is this actually what turned out to be proved at trial? Or is this what the jury instructions from the judge authorized the jury to find in order to convict, as compared with what the formal charges were? You may have a Fifth Amendment grand jury clause error called constructive amendment based on that discrepancy, something a trial lawyer is in my experience, very likely not to have focused on as he or she is engrossed in the developing trial, which may have somehow developed in a somewhat different direction from where it was supposed to go according to the indictment. The jury instructions, though, of course, are ripe. Do they correctly articulate all the elements of each offense? Do they properly include your jurisdiction's definition of reasonable doubt? Whatever is important in jury instructions in the substantive law of your jurisdiction, you want to look at all of that.
This may be a bit of a digression, but for the trial attorneys who are watching this, if your client has the resources, it would do well to get an appellate attorney on the trial team to spot these issues very soon, because things like a faulty indictment, sometimes if you don't argue those before trial,
Maybe waived.
you waive.
That's right.
Yep.
Well, yes. And so having reviewed that record, we're going to make a list of potential issues, an over-inclusive list of every conceivable potential issue, then start crossing them off rather than a short list of the best possible issues. I think we all agree with that tactic for building your issues on appeal. And we'll talk about more about this in the second hour as we talk about what goes in a brief. But while reviewing the record, obviously you're making, along with whatever other notes you're taking in a separate piece of paper, making that endless list of possible issues that you're eventually going to be crossing things off of, right? Dates when things happen to make sure you've got all your ex post facto I's dotted and T's crossed, easy to overlook that. Details that maybe have escaped notice in the course of a rapidly moving trial. So I think that's where we're going to cover in the first hour, and I'm going to see if there are any questions.